what do you see happening with central banks to make the U.S. Treasury bond lose its position as king of the global reserve central bank assets?
So I think the reason why the U.S. Treasury market is losing its share as primary global reserve asset, and we can see that since 2014, global central banks have sold $400 billion of treasuries on net, and they've bought $600 billion worth of gold on net. So from a marginal perspective, for the last 10 years, gold has, central banks have bought gold and sold treasuries. The reason I think this is happening is multiple. Number one, for the reasons I just highlighted, some of it's mechanical. When the dollar gets too strong, you sell what you can to raise dollars, not what you want to. That's treasuries. Number two, some of it is geopolitical. Treasuries for central banks are no longer risk-free instruments. If you do something the United States government doesn't like, they will take your treasuries, full stop. They've done it to Russia, they've done it to others, and that has opened eyes. The third point is a little more subtle, but it is in a world where you have peak cheap oil, which is to say we're not running out of oil, but we're running out of cheap oil. It costs more and more to find marginal barrels of oil. When we're in a peak cheap copper world, where again, we're not running out of copper, but the copper we find, the respective supplies are much, much higher, and everyone wants to electrify everything.
Thank you for joining, for all of you.
Then you can't store the reserves.
I'll turn this guy off. We've got 9 minutes till that call. Let me see if I can make sure it's not. Okay, here we go. It's not on yet, but it's okay. Let me see if this is it. No. I just want to make sure we get in line to hear Wes Christian. There it is. Okay, start listening. I'm listening. Nothing's happening. There are a bunch of people on it. It's with Junk Savy, me, Busy Brands 100, Rare DD, Daddy O, Howya, Greg, Sam Hill, Dixie, oh Lord, Dixie Normus. Dixie Normus. A lot of people listening. All right, so we have 7 minutes. I don't hear anything right now. This is going to be a unattended live stream, I guess. But anyway, we'll see what happens once it starts. I think most people are going directly to the she's not taking any questions, so it doesn't matter where you listen. Ham sent her a question, which we'll see if gets answered. Hey, lucky boy. It's too hot to go out. It's way too hot. All right, let's see if
that you're going to need to, at some point as a nation, deploy possibly into.
Maybe. I wonder why I'm not hearing anything. All right, let me leave and start again. Oh. There we go.
Hey everybody,
There
how
we
y'all
go.
doing?
There we go.
This is how we do it. We're starting a little bit earlier today, guys. I just want to give you a chance to settle in and get comfy, grab your libations, pop that popcorn, whatever it is that you do. Be prepared to be entertained. So, guys, we are waiting on Wes. Busy is my co-pilot today.
Busy.
And guys, this wouldn't have happened today without Busy.
I know.
So always
Busy's the
doing what
best.
Busy does and putting this together. So Busy, if you'll keep an eye out for Wes, that'd be great. Wanted to start the space off with a little inspiration. We, of course,
Here
today are
comes a prayer.
discussing market manipulation.
No prayer.
And Ken Griffin
Got
had
arrested?
some thoughts on market manipulation. So I wanted to share his thoughts on that and contrast that with our discussions today. So here is CEO Ken Griffin of Citadel.
It's probably a moment in time. You know, replaying the history. You've got these enormous stimulus programs from the federal government, sending checks to tens of millions of American households. And a fair number of those households did not need the cash. They put it in the stock market. And people were looking for connection. They were looking for something to be involved in. You had the rise of the Wall Street bets and the whole Reddit phenomena. And I don't want to say our stock market devolved into entertainment, but there was certainly an entertainment dimension that came into play with money that was sometimes just dropped out of the skies into people's wallets. And they took a run at
Just
the
like
stock
the
market.
money drops in your pocket from
AMC,
cheating.
Dozens of other meme stocks. I'd like to think it was a moment in time. I'd like to think that's the case. It's not how capital formation works best.
Capital formation.
A lot of it came from a place that I don't think it was very healthy, which is like, let's try to take a firm like Melbourne and put them into bankruptcy. Like, great. So you basically help wipe out the pension plans of teachers. You feel good about that? It's not Gabe's money that you're taking down. You're taking down the money for pension plans that belongs to a teacher. So I don't think it wasn't a very good moment in American capital markets history. But I think you have to replay history and go, where were we as a country? And people were locked up in their basements, kind of losing their minds.
So, I just wanted to get you guys a little fired up. Wes Christian is here. Wes, I was just playing a little snippet from Ken Griffin, CEO of Citadel, discussing who he believes is responsible for market manipulation. So, but yeah, Wes, we are very delighted to have you here. I'm going to give them a couple more minutes. We did open a little bit early. But Wes, how are you doing?
I'm doing fine, but I would add to Mr. Ken Griffin's comments, I object, Your Honor. So,
Yay! Yay!
Totally horse manure, as we say in Texas. So anyway.
Is that an official reason?
She's loud and he's not.
Texas courts. Wes.
Well, you could either that or scream liar, liar. Okay, so I
like
don't know which is more effective, but anyway, yeah. So it's
liar, liar, pants on fire is certainly something that we are very, very familiar with in this community, especially when speaking of some of our regulators in particular. So, well, guys, it looks like the gang is all here. I know we're just a couple minutes early, but the space, just to warn everyone, the space is recorded, so you will be able to listen if you missed our introduction or missed any part of it, or want to obsessively break it down and quote post it. It will be available for you. But just to give you guys a heads up, we're not going to do mics. We have a very limited time with Wes, and so
I'll turn the volume up when he starts
all the questions from the communities and sent those to Wes. A little bit different than before. We've got a bunch of questions regarding the Meta, MMTLP potential lawsuit. So we're going to try and shotgun those. We're going to try and rapid fire those so that we can get through those and give Wes a little bit more time to opine on some much broader issues. So Wes, are you up for that?
I'm up for that. I looked at all the questions. It looks about like 6 hours worth of answers, but okay.
I know.
I don't know what kind of rapid fire you got in your machine gun, but I'll try to respond to the best of my ability. So, yeah.
You know what?
I do only have an hour, just to be candid. I got 1 hour. That's it. Okay. So.
Yep. So we're going to start that off here in just a minute, guys. And actually 100, if you want to come up and do that, I don't actually have it on me right now. Wes 100 is going to read a disclaimer here really quick before we begin, and then we'll get started. Yeah, absolutely. Hey, Danny, I sent you a mic.
Here comes 100. Reading a disclaimer.
But yeah, guys, I'm going to ask the questions. Wes is going to answer. And, we'll get through as many as we
I'm
can.
sorry, her
We've tried
voice
to
is way up
consolidate them
here,
as best
he's
as
down
possible.
here.
So many people had so many questions. And so we can. And if we leave any holes, we'll have a great reason to invite Wes back. Danny, go ahead, and then we'll get started.
Okay, this space call is for educational and informative purposes. It does not serve as a vehicle of financial or legal advice of any kind. Having said that, the opinions expressed on this call are protected by the First Amendment and the Constitution for the Republic of the United States of America. Any unauthorized recording, manipulation, or tampering of speaker voices via an AI is strictly prohibited. Thank you.
Awesome. Thanks for that. Okay, Wes, let's go. So, Wes, on May 20th, 2024, Meta Materials Inc. released a press release giving an update regarding their investigation into manipulative trading activity in both MMAT and MMTLP. From the PR, quote unquote, the lawyers have now concluded that Meta has a meritorious claim for market manipulation against several parties, end quote. They quoted you. I believe Meta has an actionable case in connection with its MMAT and MMTLP claims. We look forward to working with the company, close quote. Later in the PR, they indicated that they, quote unquote, planned to share these findings with regulatory agencies and that they expect to file legal proceedings in the coming quarters against the responsible financial firms. Just want to give a little context to that for people that may not be familiar. So Wes, let me hit it right from the get-go. Have you already begun or have you completed the drafting of Meta's meritorious claims?
We've begun that process. I can't get into the details until it's filed. But yes, we've begun that process, but are in the process of, really selecting what is the best approach. Because as we all know, the main way to do this, we've tried it every other way without litigation. It just doesn't work. Is to ultimately file a claim that is sufficient to beat the 12B motion, which is the motion to dismiss. And then in doing so, get discovery across the board on everything that impacts the shareholders of MMAT, which would include MMTLP because of the one-to-one, preferred to common issue, as we're all familiar with. So yes, that's begun. Has it been completed? No, it is not, because we're trying to make some decisions to first to have the best chance of beating the motion to dismiss. It's an enormously complex decision and frankly has some guessing associated with it. So.
Okay, Wes, you actually just hinted at what may be our first no comment question, but without giving away any, and guys, I've given him full reign to say no comment if there's something he cannot answer. But without giving away any strategy, Wes, can you provide any insight into specific claims that Meta will be making against some of these potential financial firms? I mean, are we talking naked shorting, spoofing, washing trades, anything, all of the above?
Well, we're certainly talking spoofing. As the community knows, we now have 4 cases in New York. One of those is in the midst. We're almost completed with discovery, which has been, needless to say, an enormous eye-opener. Because what you learn in these cases, which everybody knows, I've been doing these for 22, 23 years, basically is the bad guys, the defendants, are always a step ahead. They're always thinking of new ways to hide things, to obfuscate things, to send them overseas, to do it through dark pools, to do it in ways that make it more difficult for plaintiffs to prosecute a claim. And so certainly in the Harrington case, which that's been pending for 3 years, and we're now about finished with discovery. We're now kind of up to speed on some of the more current methodologies being used. I can't discuss those because they're subject to a protective order. But essentially, we'll be bringing, at least our intent is to bring 12B5 or 10B5 market manipulation claims and claims under 9A and 9B, which are basically fraud claims. And then, expand it from there. We're going to start with a select group of defendants that we have identified. And then ultimately, potentially there are more defendants to include. But, we have to figure out first how to get past the motion to dismiss, to be candid with our best case.
Yeah, and of course, as you do get past that motion to dismiss and potentially into discovery, more and more potential defendants could reveal themselves. And so, but you just spoke about your 22 years of past experience. Do you have an estimate, Wes, on what kind of costs we're talking involved in litigating a case for Meta that you just outlined? Now, I don't want your flat fee, right? I just, in general, what are we looking at in terms of how much is this case going to cost?
It's a good question. And of course, all that depends on what the client's arrangement is. But generally speaking, our model is basically to cover costs, and then the rest we do on our contingency. Just to cover those costs in totality is running about $12 to $13 million a case.
Okay.
So it's large. And I will tell you, in the spoofing context, it's more expensive because of the way that the trades are routed and the way that it goes, cross-border, and the way that it both leaves the U.S. and then comes back into the U.S. That takes an enormous amount of effort. So it's hard to estimate with certainty what that cost is. But that's probably, on the high side. The more.
Hello?
Probably got a phone call, guys. Give him a minute. Hey, Wes, if you can hear me, we can't hear you.
Okay, that would cover through trial also.
Okay. So you just you gave the estimated cost of 12 to 14 or 13 million dollars.
Well, that's in a ballpark. I mean, again,
sure.
This is a guess, okay, but it's a guess based on past history. We did some cases for 6 million in costs, but again, over time, that's gone up because they make it more difficult to find all these things. There's so many different routes and avenues they can go down. So it's just, it takes an enormous effort. I can tell you that it takes an enormous effort.
So Wes, do you know, and can you opine a little bit on whether or not Meta has secured the funds for your costs?
Let's just say that's being handled right now. And that's in process. So the answer would be not 100% secured at this point, but basically, 1 second. Hey, Holly, have them hold my calls, please. Basically, that's one of the pieces that have to be completed to make this go forward. So.
Okay. Are you able to give us any indication? We in the Meta investor community have seen recently and through PRs and filings that Meta appears to be liquidating assets. Do you know if any of that funding has come from the liquidating of assets, or are they potentially seeking a venture capital investment?
This is part of what, yes. Jennifer who?
With Disney.
No, I can't help it right now. I'm on a space call. Hold my calls, please. That's on my case against Disney. I'm sorry. So anyway,
no. Don't apologize, Wes. We know you're busy.
We represent the original scriptwriter of Moana. That's a different case. Anyway, so at the end of I'm sorry, what was the question again? The
question was, do you know if Meta we've recently seen through their filings that they are liquidating assets. They just sold off their nanotech or in the process of doing that. So I was wondering, the community is wondering if that's how they intend to fund this case, or if they're potentially seeking venture capital investment.
They're not going to be funding any of it from the company. Let's put it that way.
Okay.
So let's just say the lawyers and others are going to be procuring the funding, we hope, to get this done. So.
Okay, Wes, let's talk about damages. And I know, of course, that, we're not completely into this, but when you do file your case, you do have to assert some sort of damages. In general, how do you and your clients go about determining damages? And do you have an estimated of the potential damages that we're talking in this meta case?
Really, you can't estimate with certainty, but I can tell you, unless we thought it was worth at least $100 million in damages, we wouldn't even touch it. I anticipate this to be substantially more, but I don't know, because ultimately, don't forget, even with all the proprietary methods we've developed, even with share and tell data, even with spoofing analysis, even with everything we've done, you can't estimate with certainty the damages, because when you peel back that onion, you typically find measurably more. And some of it, is better, some of it's worse, like every case. But we anticipate, it to be larger. We wouldn't be spending this much time on it, but basically on the come. So at the end of the day, I expect it to be, pretty large. And until we get into discovery and chase every defendant and figure out what their role was and how much damage they specifically committed, or what they were responsible for, I can't tell you that. I can tell you that damages typically are associated with the difference between what the company sold shares at versus what they should have been worth, but for the manipulation. And the same would apply to shareholders. Because another thing we're looking at, which again is just in discussion, because we enlarge our team, because we've got many other firms working with us now in this space because of the number of cases we have. We've had to enlarge our bench. We're looking also at possibly doing a class action, and it's separate from the company's claim, a shareholder class action, for various reasons. But there's obstacles there too, including arbitration clauses and broker agreements and other things, even though there's some case law in the 11th Circuit that says differently. It depends on, what judge you get and what district you're in. But we're looking at all the above. But in either case, the damage model presently is, and again, there's many different types of damage models, but the best one we believe is the but-for price, the difference between what shares were sold at, either as a company out of its treasury or the individuals, versus what they could have been sold at, but for the manipulation. And that manipulation could either be in commissions or it can be in omissions, something that somebody omitted doing or something that somebody intentionally did do, that type of thing.
Okay, great, Wes. Now, are you familiar with the Sorrento Therapeutics case out of the federal bankruptcy court in Texas?
Yes, we're representing Sorrento and its subsidiary right now.
Okay, so let me ask you a question.
We've been representing them for 6 months. So.
Okay, so let me ask you a question. Will Meta be seeking any type of injunctive relief like what was done in the Sorrento case, where the judge ordered a share count and then ordered the shorts to cover their positions? Will Meta be seeking any sort of injunctive relief in that manner?
Yeah, well, number one, that's really not, with no disrespect, that's not an accurate representation of what happened.
Okay.
I don't have it exactly in front of me. The judge, who's no longer on the bench because of alleged impropriety, basically, we're now with the successor federal judge, who I've been in front of, who's very good. And the predecessor I thought was good. It's just he's had some, different issues that you can look up and figure out on your own. But at the end of the day, he did order a share count. I don't think he ordered positions to be covered. If he did, I don't remember that in the court orders. Nonetheless, that case was withdrawn and abandoned. And now, as you'll probably know, I'll tell you what's in the public record. I can't share anything else. We moved to get a 2004 examination and seeking documents. We got those from the DTC. We got those from FINRA. Now we're seeking those from the audit, the spun out entity out of FINRA, which is a audit system basically that they have. consolidated audit called CAD. So basically, there's presently a motion pending in that case, and we're fixing to fight over those documents. Sadly, the Security and Exchange Commission has come in and joined the bad guys against us, saying we don't need that information. I'll be arguing that motion probably in the next 30 days in federal court here in Houston. So the injunctive relief that you're discussing, frankly, is very difficult to obtain. And the reason is, in order to get an injunction, you have to prove you have an inadequate remedy at law, which in most cases you could be compensated for by money, other than maybe the disturbance of corporate governance, which we don't believe is a successful argument. You have to show a probability of prevailing on the merits, and you have to prove that it maintains the status quo. Those are difficult predicates to prove in a temporary restraining order, which then ultimately turns into an evidentiary hearing, which is a temporary injunction. And ultimately, though, what does happen in bankruptcy court is you are allowed to seek discovery, and you'll also see in PACER, if any of your listeners go on PACER in that case, the Sorrento case, which also involves Silex.
PACER costs a lot of money.
That basically, if we're successful in getting that information, the post-confirmation estate trustee, because the bankruptcy plan was approved, it's done, but the post-confirmation estate trustee is the one who now has the ability to bring claims. Well, the good news is for us, they've joined us in our motion to get the documents from CAD, and so ultimately, I'm cautiously optimistic that we should get those documents, even though the SEC and the subsidiary or affiliate of FINRA has said no against us, which just blows my mind. But nonetheless, that's where we are.
Well, and we, of course, in the MMTLP community are very familiar with their objections and obstruction of providing that data as well. So, Wes, before we talk about the data more specifically, let me ask you a question. In your experience, in your 22 years representing companies and securities cases, when they do settle, first of all, what percentage of your cases settle versus going to judgment? And when they do settle, how often are shareholders receiving proceeds from that settlement or judgment?
And how big?
Yeah, so I have a list of all of our cases. In the first several years in New York, we weren't very successful, to be candid. Several of those got dismissed. Some of those resulted in small settlements. The first big settlement we got was Overstock. The next one was the Taser Gun Company. The next one was Pet Quarters, then Eagle Tech, and I could go down the list. But I would generally say in the last 15 years, we've lost one half of one case based on claim preclusion. Some of those settlements have been large. Some of those have been smaller. I can't get into specifics because it's confidential. We signed a confidentiality agreement. So I would say the vast majority of them, a high percentage, settled. None of them have gone to trial. I don't believe any of them will ever go to trial. That's my
Exactly.
but I could be wrong. And I'm not, what shareholders got, I don't know. In the cases where shareholders were involved alongside the company, each shareholder got their own damage model in the settlement. So just let me be clear about that. We have done cases where we represented shareholders and the company. And in that case, the shareholders got their own settlement because they had their own damage model. And the company got their settlement because they had their own damage model. In cases where we just represented the company, how many of those companies dividended out to shareholders? I have no knowledge of that because after the settlement, I wasn't really representing the client anymore, so I have no idea what happened.
Okay, thanks for that, Wes. Do you know if Meta is open to having shareholders join this potential claim with you?
I don't, but I would suggest that if that were to be the case, it would have to be a class action because ultimately, if you get more than 50 plaintiffs, you're subject to a different statute that the bad guys got passed in 1999. So SLUSA, and so ultimately, it would have to be a class, which is something we're looking at now, but we haven't signed off on, and that wouldn't just apply to Meta. That would apply to any case we do to essentially cover more damages, basically. But again, as I said, there's issues with class action. You have to get certified as a class. That's a big deal. You don't want to be going to arbitration. You've already seen what's happened to those cases that are in arbitration. It's a FINRA arbitration, and that's pretty much a joke in my mind. So, anyway.
So one more question, Wes. Typically, when settlements do happen in these cases, they are sealed, correct?
It's not sealed. The settlement agreement doesn't get filed with the court. It's a private settlement, and yes, it's subject to a confidentiality agreement. Rarely are some of that exposed. I think one piece in Overstock was 20 million that got exposed. Another piece in Overstock, and because we had two cases there, maybe 10 or 15 million of it got exposed. The rest of them have been confidential, and so my answer is assume it's going to be confidential and it's not going to be disclosed is the answer.
Okay. Are those monies disclosed in tax filings? That you know of? I know you're not a tax attorney.
I don't know.
Okay. Obviously, we want to know what the money is, Wes, but I appreciate
Get to the
I
meat
have a
of
hard
it.
enough job doing this part.
You got them now.
Well, let's drill down more specifically into the data, Wes. So last June of 2023, Meta Materials released a PR announcing that they had retained, of course, your firm as well as Warshaw Bernstein and Shareholder Intelligence Services, who we know as Share Intel, to ascertain whether, based on the data, that there was potential legal claims. So just want to make sure that everyone understands that as well. So let me rapid fire some of these questions. You once called short positions in Meta Materials stock, which includes MMAT and MMTLP, the mother lode of all naked shorts. Were the numbers collected what you anticipated? And is Meta still the mother lode of all naked shorts, or have they showed up and someone else taken the crown?
I can't get into competing cases because there probably are one or two cases, one of which we're fixing to bring and one of which is already there that's substantially larger. But it is still, in my opinion, but again, I want to be clear, that's still my gut opinion. As I've stated, until you get into discovery, you don't know, what you have, but my gut is, if you as my dad used to say, you put a gun in your mouth, what's the answer? Is still very large and a, substantially larger than the vast majority of our prior cases. I'll put it that way. That's my gut, but again, qualified opinion that we got to get into discovery and figure it out first.
Okay. Wes, was Share Intel able to collect data not just for MMAT, but also specific to MMTLP?
Absolutely not. There was nothing at the DTC about it. Broadridge didn't have anything about it. The only way we were able to collect MMTLP data, and I can't really get into specifics, is to, do it through some clients that had very large positions. And figure it out that way with respect to certain companies, certain brokers, but I can't really disclose any of that. So we did it, as I would say, the country boy way on the MMTLP side, because every avenue we went down with Flamethrower and others that we tried to help, basically nobody helped us. In fact, FINRA fought us, DTC fought us. Brokerage firms wouldn't disclose anything until ultimately we sent some very large clients in to find out some data, and that revealed some things, but I can't get into that.
Okay.
Let's just say, and as you know, I've also talked to some people in the community that have given me some data, which I'm very grateful for. So that piece doesn't have the certainty that the Meta piece does. But remember, for every piece of shareholder of Meta that came from Torchlight, ultimately, I think it was about 25% of the company that were Torchlight shareholders in the merger, something like that. Don't forget, for every share of stock of Meta, they got 1 share of preferred. So I forget what that number is, but it's, I think, what, 165 million shares or something?
Yeah, it's supposed to be 165.5, but we, of course, believe that shorts were never closed out of Torch, and so those would have been moved into Meta as well.
That's right. That's my gut too.
Yeah.
And we do have some preliminary information to indicate that on the Meta side, but the bottom line is the MMTLP, as you know, is so convoluted based on what FINRA did and what everybody else did. You're not really going to know until you get into discovery, in my view. Although my gut is that's going to be even larger than the Meta piece. That's my gut. Okay.
Okay.
So anyway.
So Wes, is ShareIntel continuing to monitor the trading data for Meta?
Yes, they are.
And
Meta,
you're receiving regular
still,
reports on that?
Meta is still paying ShareIntel. Yeah.
Wes, do you by any chance recall when exactly it was that your firm and Warshaw Bernstein concluded their assessment initially that Meta really did have meritorious claims for market manipulation? Do you remember about when that was?
I don't. I've got so many cases in my head. I don't know, but I know it wasn't terribly long ago.
I mean, was it 6 months ago?
I would say around 6 months ago, or maybe even 4 months ago. But somewhere in there, 3 to 6 months ago would be an estimate without nailing it down to a date.
Okay. Wes, do you have, from the data that you've collected, do you have a sense of how many long and short positions are held in MMAT at the time of your last report? I know you probably can't disclose it, but do you have a sense?
I can't tell you that. That'll be in our complaint.
Okay. I tried, Wes. I tried. I had to ask. And you've already told us there were absolutely difficulties. It sounds like, so for those of you that don't know, ShareIntel aggregates data and information from 3 sources: the DTC, the transfer agent, and a company called Broadridge, who aggregates information from the brokers directly. So, Wes, you did say that when it came to MMTLP, which always seems to be the exceptions, that the DTC and Broadridge dug in and would not share data. Correct?
No, they wouldn't.
Okay, thank you. Appreciate that. Let's talk about the transfer agents, since I just mentioned they're part of the ShareIntel process. There's been a lot of speculation here in the MMTLP community and questioning as to whether the transfer agent, who is also the transfer agent for Meta, AST bought out, which is now Equinity, that they're working against NextBridge and its shareholders. We have seen some inconsistencies with 2 unregistered identifier numbers being used for our NextBridge shares. Do you have any sense that AST and Equinity are working against the best interest of Meta Materials, the company, or its shareholders?
I don't. You'd have to ask David Winger that, but I can tell you with certainty that many brokerage firms have created their own QSIP number internally.
It's just
to in essence keep track of shares that really don't exist, in my view.
They don't exist.
I can't prove that at this point, but that's my very strong gut feeling.
Yeah.
And so it's something I've never seen done before, where in essence to create, fictitious shares from real shares, let's call it, a separate QSIPs being kept. This is my view. Okay.
Okay. Let me ask you a question. Hold on just a second. With the data collected that you have seen, do you see any relevance to MMTLP? Is there cooperation with Meta and NextBridge? Can you share anything in that regard?
I think everybody is cooperative in that entire link.
Okay.
As you know, or the community knows, the flamethrower guys spent a considerable amount of money trying to pursue claims to really benefit everybody, because ultimately discovering what happened with MMTLP and what happened with Meta inures to everybody's benefit. It inures to Meta's benefit. It inures to MMTLP's shareholders' benefit. Even if you sold shares, which again, don't forget, in order to have standing as a plaintiff, as an individual plaintiff in a class action, you would have to have sold shares during the class action period. If you didn't sell shares, you don't have a claim under current law, okay? So at the end, you may have a claim against your broker if they don't have your shares, but you don't have a claim for market manipulation under 10b-5, because 10b-5 is shares purchased or sold in connection with the manipulation. So you have to be a seller or a buyer. And in these cases, generally speaking, you have to be a seller. But absolutely, the Meta people are cooperating, at least as far as I know, with the MMTLP people, because they're derivative of each other. They're symbiotically attached. And certainly the main people at NextBridge, who are major shareholders, don't forget this. They are major shareholders, big time, of Meta and MMTLP, who equally got screwed, and I know that for a fact. Okay.
Yeah.
So they are cooperating as much as possible. Each of them have duties to their own shareholders, so you have to separate that out. But there is a common interest in figuring out, as I would say, who is behind the curtain on the yellow brick road. Okay, who is back there? Okay. I have some great ideas, but it's all speculation at this point, other than what we know for certain, because there'll be defendants if we can get this thing filed. So, okay.
Well, speaking of that, I'm hoping I'm going to ask this question in a way that you can answer it, Wes. So recently, Devin Nunes, CEO of Trump Meeting Technology Group, put forth a list of potential market participants who have suspicious trading activity in DJT. Do you see any correlation between the firms on that list and those who potentially manipulated trading in MMAT, or even NWOB, Northwest Bio? Is there a correlation there from the data that you have? I'm not asking you who. I'm just asking if there's a correlation.
There certainly is some overlap, I can tell you.
Okay.
Yes.
Well, there you have it, guys. Dig in. So let me ask you, if Wes, if for any reason Meta does not end up moving forward for whatever reason, or even if they do move forward, is there an opportunity for shareholders to gain access to the data?
Only if they file.
Well, certainly if we're able to bring a class action and they become clients,
they have to file
in that class action, and certainly typically the data can be shared with the clients, although you need to understand these protective orders, which we're officers of the court. And so even though I try to be, reasonably aggressive in litigation, we're always very ethical. Even though I was sanctioned once in my career by a court in one of these stock fraud cases back in like early 2000, because the court said we didn't have enough facts to sue that defendant. They were probably right, but who knows? But getting one defendant wrong out of hundreds of defendants we've sued in this space is probably fair and reasonable. Anyway,
yeah, it's bound to happen.
Yeah,
so it's nice to know that.
And John O'Quinn said he wore it as a badge of courage in honor of the working man. Okay, I wouldn't go that far because I'm big on supporting what judges say. But my point is, protective orders have different categories of information. Some of it is attorney's eyes only that the clients can't even see. So that's some of the stuff that's very proprietary, like, the algos that are being used, for example. Those are attorney's eyes only, that kind of thing. So I can't answer that with certainty, but generally speaking, clients should be able to see what it is when information comes in. They would have to sign the document saying that they're subject to the protective order. But if it's attorney's eyes only, then no, they would not be able to see it. So it depends on which bucket that information resides in.
Okay, so let me ask this question. We, of course, as investors, have seen what appears to be the managed downfall of this company, quite honestly. So there's lots of questions about the data that was collected by Share Intel. Is that considered an asset of the company? And what happens if the company goes into bankruptcy? Can the shareholders get access to it? Can it be purchased?
Are these the questions you want to ask?
Well, I'm not a bankruptcy lawyer, even though I've litigated in bankruptcy, including some of these cases like Sorrento or like Razor that we did in Delaware. That was like 10 years ago. Basically, whatever assets the company has in a bankruptcy are always potentially up for purchase. It's very complex, though, because generally speaking, you cannot
These are
assign
not
tort
great
claims. You can
questions.
assign contract claims, but you cannot assign tort claims, generally speaking. So you'd have to assign the right to receive the proceeds and then get a power of attorney coupled with an interest in order to purchase that out of bankruptcy, or the post confirmation estate of the bankrupt estate could bring the claim on their own, which means, and I've done many of these cases across the country, including against Signature Bank, who's now broke. So we're going against their insurance in Florida, not in a market manipulation case, but in a Ponzi scheme case. What happens is that post-confirmation estate trustee is there really for the creditors, which generally is including the shareholders, because as we all know, in a bankruptcy, generally speaking, the shareholders are at the bottom of the barrel, right? So ultimately, in Sorrento, for example, the shareholders, as usual, didn't, in my recollection, didn't get anything out of the bankruptcy. But the post-confirmation estate trustee who's supporting us in getting this information in the 2004 examination, if we're successful in finding the documents we need, filing a claim, and ultimately monetizing that claim, then that money would go into the estate to pay creditors. And so that is a way by which, the shareholders can benefit. Or I've seen other situations to where some very large shareholders who had a lot of money went in and purchased that claim out of bankruptcy, which we did in Razor in Delaware. So there's multiple ways the shareholders can benefit from that, depending upon, their ability to purchase for cash the claim, or alternatively, where the post-confirmation estate brings the claim and then pays creditors that way, kind of like is going to happen, I hope, in this bank.
Take them somewhere that helps us.
Okay, thanks, Wes. Really appreciate that. Appreciate your candor as well. So one more question, Wes. Hang on just a second. When in the PR, it mentioned that this information from Sharon Tell will be shared with regulators. Do you know if Meta anticipates any civil enforcement actions from regulators, potential criminal referrals to law enforcement? Are there any plans at this point, or are they just going straight for civil litigation?
I have no idea. I'm only responsible for the civil litigation piece.
Okay.
And I think that includes Alan Pollack. That includes, other experts. I can't mention some of their names. That includes other law firms, because as I said, we've increased our bench to include other law firms in this litigation, most of which you can go find out by getting on Pacer in the cases we have in New York right now. So.
Yeah. So Wes, a little bit earlier, you mentioned arbitration. And of course, this has been kind of, just an insurmountable wall for retail, especially retail investors. Of course, we sign those brokerage agreements that, sign our lives away to arbitration. And you've seen in, for example, Richard Hoffman, who's a community member, he's spent enormous amounts of time and energy exposing the fallacies and the problems with arbitration. I'm not sure if you're familiar with the Bizzell law firm. They, of course, represented our client in our coastal waterways, the Trade Station in the Southern District of Florida. The plaintiff there is arguing that Trade Station violated various elements of their brokerage and lending agreements. Therefore, they're asking the court to render the agreement void, which includes the arbitration clause. Can you opine just for a few minutes about your general thoughts about arbitration? And do you think that this argument, if successful, will open the floodgates for a new way that investors can get restitution for fraud?
All right, let him answer.
Well, first, let me say my understanding was that Mark Basile, who is a colleague and a great lawyer, is at least one of the firms that's handling that case. Is that not correct? I thought he was handling the Trade Station case.
No, he is. No, this is it is a shareholder lawsuit versus Trade Station. It is the Basile law firm, correct?
Well, Basile, I'm sorry. When you said Bezel, that's what.
I'm sorry, Basile.
It's Mark Basile. But anyway,
Basile.
at the end of the day, he's a great lawyer. I think it's a unique idea. What I like about that case, so to answer your question, so I don't seem to avoid it, I can't really answer the probability of success. I know, generally speaking, federal courts and state courts, but especially federal courts, honor. If you want, I have a saying: if you walk past the conference room where they're signing an arbitration agreement, you're subject to arbitration. So, I mean, that's how broad it's interpreted. So breaking that cycle as a precedent in American jurisprudence, I think is going to be very difficult. What I think is a better idea that Mark
Is
Basile
the
has
class-
spread is the RICO claims. He and I talked
the
about
RICO
it years ago. Don't forget, under the federal statute, which is how we're bringing cases for the most part, we want to just go to New York, and New York doesn't have any private cause of action state law claims we can bring. There is no RICO claims, okay? And New York doesn't have a state RICO statute either. But under federal law, the bad guys smartly got that excluded in the late 90s to where you can't bring a federal RICO claim in a market manipulation case. Not the case under state law. In fact, the Eagle Tech case, which we did years ago, brought racketeering claims against brokerage firms and others in Fort Lauderdale, Florida, in
That's
state court.
interesting.
We correspondingly did 3 cases in
That's
Atlanta,
interesting.
Georgia, including the Razor case. Including the Razor case and including the Taser gun case using Georgia racketeering. We brought another case in Utah, which is the one we lost on claim preclusion out of Georgia. So using state RICO, if you can get jurisdiction over the defendants, which my understanding is a train station is there in Florida, so that shouldn't be an issue, but I don't know. So I think the main thing to accomplish there is to pursue those RICO claims and to seek information, because ultimately finding out who trade station lent the shares to, finding out, what they didn't deliver, either failure to deliver or failure to receive. Don't forget, there's for every failure to deliver, there's failure to receive. Both of those parties, in my opinion, are liable
I
and
agree with that.
participated in the market manipulation scheme.
That's your broker dealer.
Which is
failure to
another
receive.
new theory we're going to be pursuing here in cases. So.
Awesome. Thanks for that, Wes. So Wes, I want to shift gears a little bit and talk about state attorney generals. You're talking about state RICO claims and things like that. But one of our shareholders had an experience a couple of months ago. She was meeting with the SEC's ombudsman office in Washington, D.C. several weeks ago. And in what was a 45-minute appointment, it turned into a 2-hour discussion. They were very pleasant, empathetic, complimentary of the efforts of what Greg McCabe calls the MMTLP Army, until the shareholder mentioned work with the attorney generals, at which point she observed a notable shift in their demeanor, the tone of their conversation. The SEC representative even went so far as to discourage our efforts with the state AGs by saying that Congress would no longer work with us if we worked with state attorney generals. She reached out to her senator, who promptly said that was absolutely false. Wes, why are the regulators and the market participants afraid of state attorney generals?
Well, let's just start by saying you're talking to Noah about the flood. Okay, so where do I start? Let me just make this simpler. Okay.
Good boy.
I want you to think about when big issues really occur on a national level, who has solved them for the most part in litigation. Let's look at the issue with tobacco, who was putting toxic substances allegedly in filters. Who solved that problem?
Peter Angelos.
Who's trying to solve the problem with human trafficking? Attorney generals. Who's trying to solve the problem with opioids? Who stepped up? Attorney generals. So is there a business plan? And I can't give specifics, so I'm just going to tell you that. Don't ask me the questions because I can't give the specifics. But all I can tell you is attorney generals can file suit in their jurisdiction. Why? Because as some of your listeners have posted, I've read some of the, I don't really get on Twitter, as you know, because I don't have time. But I noticed some of the posts and getting prepared for this call talk about the pension funds that have been robbed. So imagine attorney generals protecting the pension holders, the teachers' retirement funds, the policemen's retirement funds, the firemen's retirement funds, the other state workers' retirement funds. That's trillions of dollars. truly that are getting pilfered by this process.
Exactly.
I know
like
that
him.
because I've already looked
like
at
him.
it, and we've actually spent the money to look at key states that have state racketeering statutes. That's treble damages, boom, 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 right? Big stick. And that applies civilly and it applies criminally. And the predicates kind of cross over from civil to criminal. Imagine an attorney general bringing those cases in their jurisdiction and how that would get done.
They got to go
And
after
also
Trump
how much
first.
money that would bring to the states. Okay.
They got to go
Every
after
state
Trump
needs
first.
more money. Every attorney general wants to right wrongs. And frankly, they're not as politically compromised. All people in politics at some level, I'm not going to say compromise, but they have constituents, they have people that support them, they have people that lobby them. Okay, that's just the way of life. But separating the lobbyists from right from wrong, my belief is that attorney generals are more inclined to do that, especially if they can monetize it and protect their people and use that as a platform. So as my dad used to say, put that in your pipe and smoke it and think about it, because I'm going to submit to you that that may be a better way. I'm not going to sit here and bang on the SEC. Everybody knows where we are, you know, in all the SEC amendments. You can still sell shares that you don't deliver. That's still happening. You can still lend shares 10 times. That's still happening. You know, market makers are still selling shares, in my opinion, that they don't deliver, and using the one exception left in Reg Show. I could go down the list. So who's more likely to do it? I believe AGs, but let's just say that movement is out of the gate, and where it goes, we'll have to see.
Fantastic. You know, Wes, and I think it's part of a greater battle that we're seeing in this country between states' rights and federal rights. You know, states are far more equipped to deal with the situations in their states.
Okay,
And
we
when you're
got his
talking
point.
about
Ask your
some of
next
these
question.
companies that are shorted to death in the states
Just
that they're
ask the next
domiciled
question. We
in,
got his point.
you know, it makes more sense that the AGs would protect that, not only for jobs, for tax revenue and everything like that. It just seems like that is where the battle really should be taking place.
I second that motion. All in favor, say aye. Aye.
Okay, then. Okay, Wes, we have about 13 minutes left. And so I wanted to take the opportunity. You and I opined about this in a call a couple of weeks ago, and I wanted to give you the opportunity to talk about this. So it appears that there is a groundwork being laid to establish a collection of legal decisions that bring the various market participants to account of what may be considered financial terrorism. There seems to be a groundwork being laid to purge our markets. We see that with President Trump's Executive Order 13838, which references U.S. Code 50, dealing with unusual and extraordinary threats, declaring of national emergencies, exercising of presidential authorities. Of his 200 plus executive orders, that is one of the 70 that remain. We also see, like you talked about, with the various state RICO statutes. You mentioned earlier the Harrington case, where the courts, are determining that brokers can be held liable for the criminal acts of their clients. We also see from Public Accounting and the Oversight Board, Section 317, that states that auditors may be held liable for the illegal acts of their clients as well. We haven't talked yet about the Jarkizi case. Of course, that was argued and forwarded to the Supreme Court, which challenges the civil enforcement actions of the regulators. And of course, we're awaiting a decision on that one now.
I guess I'm being too impatient.
First of all, how do you see or anticipate SCOTUS ruling on the Jarkizi case?
Wow.
Sorry, that was a mouthful. I know.
It's a great question. You know,
I got to a good question though.
At the end of the day, it would seem that to rule on our side of the V. That would be my guess. But just be clear about this. I'm not the scholar on our team. I'm the street fighter on our team. So I'm not the writer and I'm not the scholar. But my guess would be to err on the side of, you know, a right to a trial by jury. Okay, that's my guess. I will tell you that, and I said this in the last call we had 6 months ago or whatever, but it's even more so true now. There's more awareness in the attorney general community. There's more awareness in the regulatory community. There's certainly more awareness of Congress because the MMTLP community, frankly, for the most part. Although I will tell you, and I'm not going to sit here and bang anybody, but I'm not going to really spend any more time with Congress. I've got hundreds of hours in that, and at this point, I've got nothing. I got some letters that got sent out, but that's a letter. What's that going to do for us? So, at the end of the day, I think it's up to us. I'm going to take us back to the Magna Carta and Runnymede in England, and the people are getting starved, which I would say is analogous to what's happening to the MMTLP community. And we have to continue to rise up and get everybody on our side of the beat that we can. I will tell you that's increasing at a very rapid rate. I will also tell you, though, the bad news is that I believe this problem is so large that nobody's going to wave a magic wand over it. It's too large to make it all happen. How it gets resolved, I don't know, but it's good. It continues to get larger. And what the magnitude of it is such a large number that if I told you what I believe, you wouldn't even believe me.
I would believe you.
At the end of the day, I think that is a problem. It's a problem for whoever wants to join the party to resolve this. But we have to start with everybody recognizing who's done this and the magnitude of the problem, and then we can figure out a way for restitution. That's in part going to be through the civil litigation route, which is our route. It's in part going to be by the government people, probably at the AG level, in my view, that join us, or maybe even state securities commissioners that join us, because that's another entity that has authority to bring at least civil enforcement and refer it to attorney generals for criminal enforcement. Ultimately, we have to keep plowing ahead. We have to be diligent. We have to do everything we can to move this forward, knowing that it's an absolutely hellacious battle. It is a hellacious battle. I can tell you just in one case, we're fighting 45 lawyers on the other side. There's only 3 defendants in that case, okay?
Lots of lawyers.
So magnify that times 4 cases. That's why we've had to enlarge our team, and we're going to continue to enlarge our team. And I'll tell you why. Because more lawyers are seeing that this is wrong, and more lawyers are seeing that this is important to our country, and more lawyers are seeing that, frankly, they can make money at this. Ultimately, it's just a long haul. I'm hoping to speak soon. I've been invited to speak at Liberty University. And, that university is all about, making a difference in people's lives, including the lawyers at that law school. And so there's enough lawyers out there, believe it or not, that do care, that want to right wrongs. And so we have to enlarge that group and keep plugging. It's that simple. Being guaranteed of nothing, but at least know that we can sleep well at night, trying to be on the side of right and not the side of wrong. So.
Yeah, absolutely. Wes, you mentioned the last space call we did with you. It was actually with you and the great Robert Shapiro. And I asked you, and I asked you a question that elicited this response. And I apologize, I don't remember if it was you or Dr. Shapiro, but one of you said, it's time we audit the DTC. Pulte, the billionaire Pulte, recently said the same thing. And I warned him, I said, ooh, you said a very bad word. You're in trouble. Wes, as a means of cleaning up this system, are we ever going to see an audit of the DTC?
Well, let's include in its subsidiaries, because if you look at the DTC, at least on the surface, their books balance on the share count, right? But when you get to the NSCC and then you count ex-clearing and you count other things, that's where it gets out of whack, right? This is my view. This is my opinion. I don't know the answer to that. And you brought up accountants earlier. I want to tell you something I learned the hard way. I don't know that the accountants are vulnerable here, and I'll tell you why. The accountant's job is to audit the cash or capital on hand that the firm has in order to make good on the delivery of the shares on the day of the audit. The auditors, because we've deposed them over the years, do that job. What the auditor said off the record was, it's not my job to count shares, okay? I see that they have a failure to deliver. I look at what it cost on that day to deliver the share. I make sure they have the capital in their account to be able to cover that share. That's their job. And so ultimately,
Let's see.
the audit has to consist of
Let's
not
see.
only the left side, which is the DTC, the NSCC, and
Let's see.
affiliates, and that would include, now we're going to get really complex, that would include also going to Euroclear, that would include going to CDS in Canada, that would include going to Germany and other places. Because one of the things that nobody's figured out yet, even though the amount of trading stemming out of foreign nations is increased, how all those shares clear and all the avenues it goes through. You know, as we discussed on the last space call, the number of fails to deliver overseas is astronomical.
Yes, it
Okay,
is.
astronomical. But who's behind it and all that, nobody knows yet. But the point is, it's not just auditing the DTC respectfully. It's going to take auditing, you know, the consolidated group, because don't forget, you know, the DTC somehow is involved in CDS and somehow is involved in Euroclear and on and on and on. This is a global problem. It's not just a U.S. problem. And that global problem is getting larger. And I submit, I can't support this today, but it's my strong belief that the percentage of carnage that's being inflicted in from offshore venues or foreign nations is being larger. And I believe, again, speculation, that the main reason for that is it's harder to get that information. This is all about getting the information that is down about 9 layers that you have to peel back of the onion. Just an absolute gargantuous task, to be candid. And so, you know, I don't know that we'll ever get to the bottom line, but again, you do it, in my case, one case at a time, while at the same time you pursue the regulators, you pursue everybody else that's supposed to be doing a job to protect investors. That's what they say, although they show up on the other side of the V in Sorrento, which blows my mind. So that's what I think has to happen to make it
3 more minutes.
expose it in totality.
Okay. Well, Wes, we have 4 minutes left, and I wanted to, first of all, thank you for your time. We got through most of the questions. I actually edited a little bit, but we got through most of them. So I really appreciate that. But I also want to say, you've hinted at it many times, and you and I have spoken privately. I know that you have been here the whole time and that your fingerprints are on everything. And I wanted to thank you for the work that you're doing for the retail investor community and give you now 3 minutes to share any additional thoughts that you want to share with us before we go today.
Yeah, so I think the mission is for everybody to keep doing what they're doing, and anybody in the community. I know you've got one person I'm going to be talking to that really has, you know, critical information that they can actually support. I'd love to see that. Secondly, be patient. This is a slow process because the cost of these cases, getting it all done, frankly, is very complex. But I will tell you, everybody on the team, and again, the team is enlarged, is putting in a lot of time and effort into this. But the battle on the other side is unimaginable. It's truly unimaginable. And I've been blessed to do a lot of cases in my 45-year career. This by far is the toughest group of cases ever. Hence, we have to bring in a lot more people and frankly, raise a lot more money through every means we can. So at the end of the day, because again, experts, separate from, you know, what it costs our firm to do and other firms to do the work, there's tons of experts and consulting experts that are enormously expensive on these cases, all of whom, you know, can't be paid on a contingency. They have to be paid hourly. Otherwise, you'd be able to impeach their opinion. They can't be opining about how bad the defendants are if they get a piece of the pie, right? So they have to be paid hourly. So I encourage everybody to keep it up. Know that we are continuously making new law in these cases, whether it's making brokers liable, if we can prove reckless behavior, intentional conduct for their customers, that's huge. Whether it's exposing the direct market access machines, you know, in Canada and other places, and that carnage there, whether it's exposing and figuring out all the different ways these trades are routed which is mind-boggling. It's like a rat maze on steroids, okay, once you really drill down on it. Ultimately, our mission is to try to figure out a way to help everybody. The class action thing is going to be the latest thing we look at to try to help shareholders directly. Whether that works or not, I don't know. This isn't a typical class action like you file in a case where, Enron was worth 10 cents and you bought it for $25 as a purchaser, but the auditors lied and the board lied and it was only worth 10 cents. Our case is the opposite. You bought it, you sold it for, $10, but it was really worth 50 because of the manipulation. And of course, proving all that takes, an event study, it takes a regression analysis, it takes a lot of incredible hard work. And to do that analysis, you got to get all the records. And gathering the records when you have to go through 1, 2, 3, 4, 5, 6 brokers to get, to find one share, and then multiply that times, hundreds of millions of shares, you can imagine the document review is mind-boggling. So ultimately, I can say we're still hot on the trail for now. But again, each day we take a day at a time because you just have to be relentless. We're going to try to do what we can for everyone. But again, how that pans out, is left to be, determined. So I honor each one of you for staying on this path. This is truly Runnymede. Go read about the Magna Carta and Runnymede. This is Runnymede stuff. Okay, this is as a good friend of mine said. It's either the courts or it's the streets. Okay, and so this is going to get resolved one way or another because this truly has enormously damaged Americans, hundreds of trillions of dollars, in my view. That's my view. So we have to keep rising up. We have to do what we can. And anybody that doesn't do that, frankly, is a traitor. Okay, so that's the way I see it.
I like Wes Christian.
Well, Wes, I've said this many times to the MMTLP community. They've heard it over and over and over again. I'm going to say it to you. It's the right people in the right time for the right fight. And we're so grateful that you are one of our people. So they messed with the wrong ticker this time. And we're going to continue that fight. And we appreciate you doing the same. So, Wes, thank you again for your time. We are 2 minutes over, but I think for our record, we did really good. So thank you. And I look forward to it.
Thank you and go forward. And we're each going to do our best. Okay?
Yep, absolutely. Thank you, Wes. Guys, we're going to go ahead and close the space to preserve the recording. Busy is going to open up the after party so we can talk about Wes while he's gone. And we'll continue the conversation there. So a lot of information dropped today. It's going to take us a bit to cycle through it, but we'd love to have your thoughts. So again, thank you everyone for coming. And
she closed it on herself. She ended it right on herself. Curtis put out a song from Kid Cudi. People told me to slow my roll. I'm screaming out, blank that. I'm a do just what I want. Looking ahead, no turning back. If I fall, if I die, know I lived it to the fullest. If I fall, if I die, know I lived and missed some bullets. I'm on the pursuit of happiness, and I know everything that shine ain't always going to be gold. Yeah, I'll be fine once I get it. I'll be good. All right, let's go through some of your points. It's all fraud. Bring on a seat for Patrick Byrne from Kitteridge. I know she has a melodious voice. We didn't learn anything. I agree. It's disappointing. One question I had, I don't know what you think, Kit, but he was talking about, I think he called it a but for, the damages are what you could have gotten for your stock, but for the manipulation. And I just would have liked to find out if Nextbridge were to raise money now or in the next few months, and they had to raise money at a lower level. They certainly have to do it later than otherwise, but if they had to raise it at a lower level, but for all that manipulation, would Nextbridge have a claim that they could go after the criminals? But oh, here, I tried it. Okay, Kit is great. Let me see if Busy opened a space, because we can join it if he did. Okay, there's Busy. We can join it. I at PQ management, those different numbers only identify the placement holder. That's it. I agree with you. Kit, this is right. And, earlier, I don't know if you were on, I was accused of, if people have a different opinion, then I shouldn't call them liars. But I think people saying otherwise, unless they're just confused, are lying. That's what I think. That's what I think. So they try to get you to be fair, but let's see if anybody's talking. Nobody's talking. Everybody's talking at me. I don't hear a word they're saying, but only in the shadows of my mind.
Shares, like for example, back in December 2022,
I'm a speaker.
AMC, Bed Bath & Beyond,
Let me see
GameStop,
if I can get this on there.
and several other stocks were listed on the Austrian Stock Exchange. And then suddenly all those stocks had an explosion of failures to deliver. And so I was just curious if they're kind of tackling anything on the international level as opposed to just the
I can't get it up here.
United States level.
So here,
But,
I'll bring this down.
But yeah, it looks like they're fighting a good fight, and
I can't move it. It doesn't look like. Let me see.
Go ahead, Savvy, if you're back. I don't know if you're back, but yeah, it is
I
a good
am.
question.
Yeah, so, Michael, we had so many. I had 5 pages of questions for him, and we got through about 4. So that was good for Wes and I. Neither of us are known for our brevity. And so, that was.
So I don't know. That's not
informative for you guys. Michael, I don't have an answer to that. And I think he kind of indicated he doesn't as well. But what I do know, I was just recently, you guys know that South Korea has been cracking down hard on illegal market manipulation. And one of our investors is actually meeting with them and has asked me to supply some information. So we may be able to provide our own pressure there. And so they, of course, are out for blood. And we'd be happy to put the knife in their hands. So
that sounds great to me. We have someone in our community that from South Korea, actually, and he has a YouTube stream he does there that actually gets pretty popular. But they actually had, I think, 10% of the shares traded for Bed Bath were in South Korea. And I just know that there's different international rules. Like the United States is one of the few countries, if the only one, that doesn't allow contract for different shares. And it's just mind-blowing to me that somehow those shares aren't allowed here, but you can borrow them from another country and then sell them here as if they're real shares. And somehow that's okay. It's just the weirdest thing that's legal. But it is good to know that people like countries like South Korea are cracking down on it.
Good to know.
yeah, absolutely. Hey, Busy, people are complaining that the space is glitching really bad.
This one or yours?
No, yours.
that
Well,
I know
you-
ours,
Country
mine over there
boys.
was bot attacked, guys.
Yeah,
We know
they can
there's nothing we can do about it, but
blocking, and
yeah, I was
deleting
blocked.
comments. So yeah, they tried, but I mean,
Ain't it good?
uh,
to know
I seems to be
Still a
okay with
few.
me. I got 5.
Okay.
Can everybody hear me? Just
Country
thumbs up
boys.
from the
Yeah.
community.
Yeah, I think we got you.
Heard you were
Okay.
slow
Mark, I know that you're on speaker stage. Anybody in the listener?
coming down
thumbs
from
up.
Caroline.
Can you guys hear me?
Yeah, I'm actually, oh, there we go, one person.
Yeah, I'm getting thumbs up. All right, go ahead, 100.
Yeah, no, I wanted to take a stab at Michael's question. No, it's a bleeding of the lines, and I'm going to give you some examples. The Department of Treasury utilizes their relationship with the Pentagon as well as the Secret Service through FinCEN. And there are certain laws, like Chapter 115, treason, sedition, and subversive activities, that include seditious conspiracy, 2384. And there's the concentration of accounts that is under U.S. law, 31 U.S.C. 5318. Compliance, exemptions, and summons authority. And then you have executive orders on top, which would be Executive Order 13848, not 13838, 18848. So just to make that correction. And the subsections of 50 USC 1701 and 1702. All of these statutes indicate and give the power not only to the U.S. Treasury, but to the states to activate as participants for national security reasons. So if the states raise an international claim, all property that is held via U.S. assets can be addressed as a national security matter. It cannot be addressed independent of that. So there's a conjunction of different things that are involved. So it can be addressed, but it has to activate multiple areas of.
But since they're not actually shares, it's just a contract with an international bank that they're agreeing to pay the change in price. So it's just something that tracks the price. So is that really considered, is a GameStop share internationally considered like property of the United States? Or is it considered property of the United States once it's borrowed and then sold here?
If the transaction involves a U.S. asset, then yes, because technically under these statutes that I referred to, they deal with the organizations that handle them. And if there's a break or a chain of custody, then it becomes an even more sensitive issue for the U.S. government to get involved. You're basically committing fraud. Yeah.
I hope they're doing it. I mean, I don't know. Do you have any, do you think that that's on the horizon? I don't know. I mean, who would be following up with that?
Well, there's a lot of information that suggests that the U.S. government has, that's the whole purpose of why FinCEN was created after the Patriot Act in 2001. So the advancement of that technology and the services in which they provide for the U.S. government are indicated not only through their enforcement actions, but also through executive orders. So there is indication that they are involved, especially when sanctions are in play.
All right, let me move on to hands real quick, guys.
Wow.
Call from 1-918-633-8919.
Let's go, John.
I have no access to my other accounts and have had a nightmare all day today with it. Savvy, great space. I think we got a lot of insight in that the assets are not going to be used to fund the legal efforts.
Much more we're going to learn.
So I thought that was very telling, and I think it gave us a lot of hope for the MMAT investors.
Yeah, I think Oh, wait, John, I think you just locked out. Let's give her.
No, I'm here.
Oh, there you are.
I'm
Okay,
here.
go ahead. I'm sorry, I didn't want to interrupt you.
All right.
No, I stopped.
I
Oh,
think
okay.
this is
So
going
what
to
I was
be
going to
kind of
say is,
a
yeah, that was one of the
regurgitation.
things that stuck out in my mind. There were several
So-
things, but guys, I have a hard time when I'm in the middle of that hearing it, so I'm going to have to listen to it again. The recording's intact. I just went and checked it. People said it kept looping the first 2
you
seconds.
can listen
but I
to
went and
her
checked it.
call
Seems
again.
fine for me.
Thanks for coming on.
But yeah, he indicated
What I
that
heard
to me they would
is
be giving private
time, money,
so
and-
potentially through a
and
venture capitalist firm.
uncertainty. So
Also, he
again,
pointed out that
I
it's at least
really
$100 million
emphasize
case. That
your
venture capitalists
best
don't even
chance,
something
in my
unless it's at
opinion,
least
of
that.
getting a
So that
return
was
on
something
your
that he confirmed
investment
as well.
is getting the
But
real
much to
shares.
the disappointment of the MMTLP community, Broadridge
So I'm going to cut it
and
off
refused to
there.
give
You
up
can go
MMTLP
to
data. So
Twitter
why,
and
oh
join
why
in
are we always the exception?
MMTLP
Now, of
after
course, they
space
can,
with
you know,
Wes.
look at
Let's
that,
talk
how many
about
of the shorts from
it.
Torch
So
were
with that, I'm
moved
going to sign
and
off. Wish you
repositioned
each
into MMAT. That will, of course,
love,
give them some
peace,
clues.
success,
Unfortunately, they just aren't
and
giving up the data. But remember,
the
guys,
wag
only
of the tail of the
2.65
happy
million of the
dog
short
today.
positions.
So cheers.
Yeah.